This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about insurance fraud in Louisiana, which is quite unique, and about 3 cases that were dismissed because the suit that had been filed against an insurer did not insure the plaintiff. McClenny, Moseley Associates, MMA, has had serious problems with the United States District Courts in Louisiana and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct, to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. In April and May, several cases have been the subject of motions for summary judgment from insurers who were sued by MMA, who had been sanctioned by the district court and new lawyers took over the cases, only to find that the plaintiffs had no right to sue since they were not insured by the insurer defendants. For a representative sample of these 3 cases, which are 3 of many, let's consider them. In Ave Duraresu versus Farmers Property, the U.S. District Court for the Western District of Louisiana on April 26, 2024, granted summary judgment because there was no genuine issue of material fact for trial because farmers did not insure plaintiff. In Hester Cole versus Foremost Insurance Company, the same court on the same day, April 26, 2024, granted summary judgment because there was no genuine issue of material fact for trial because Foremost did not insure plaintiff's property on August 27, 2020, the year of the hurricane. And then in Terry Ramirez versus Atlantic Casualty, the U.S. District Court for the Western District of Louisiana on May 7, 2024, by James D. Kane, Jr., U.S. District Judge, the motion for summary judgment filed by Atlantic Casualty was granted, and the motion was unopposed. That suit dealt with the alleged damage to a residence in Lake Charles, Louisiana, as a result of Hurricane Laura, which made landfall in southeast Louisiana on August 27, 2020, and Hurricane Delta, which impacted the same area on October 9, 2020. Plaintiff, who was then represented by counsel from the law firm of MMA, filed suit against Atlantic Casualty on August 25, 2022, raising claims of breach of insurance contract and bad faith. Therein, the plaintiff represented that he was the owner of the property and that the property was insured under a policy issued by Atlantic Casualty. All cases filed by the plaintiff counsel had been suspended due to concerns about misconduct committed by the firm of MMA. New counsel enrolled for plaintiff, and the stay was lifted. Atlantic Casualty moved for summary judgment, showing that plaintiff is not the owner of the insured property and is not listed as a named insured under the policy, and requested that the court dismiss plaintiff's claims with prejudice. Louisiana law provides that an insurance policy is a contract and its provisions are construed using the general rules of contract interpretation in the Louisiana Civil Code. The policy at issue is a commercial lines policy that provides lessors risk coverage to several dwellings, including the one at issue. Darrell and Shirley Crotchet are listed as the named insureds. According to Atlantic Casualty's records, they are also the owners of the property, and plaintiff was a tenant at that address. The policy provides that certain individuals, such as employees, may be considered insureds in connection with the business run from that property. However, there is no basis under the policy to consider that the tenant has an insurable interest in the immovable property. Accordingly, plaintiff cannot maintain a claim for breach of contract against Atlantic Casualty because he's not an insured. In the absence of a valid contractual claim, plaintiff's bad faith claim must also fail. The motion for summary judgment was granted, and all claims in that matter were dismissed with prejudice. The result of these three cases, among just three of many, indicates that the MMA firm had a problem with the truth and filed suits on behalf of people who were not insured by the insurer defendant, and was as a result a suit based on fraudulent allegations. The litigation among MMA, its lenders, borrowers, and clients is ongoing in several courts, including the U.S. Bankruptcy Court. The last 28 issues of my Zelma's insurance fraud letter has described the problems faced by MMA and insurers in the state of Louisiana who are required to defend false and fraudulent lawsuits. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you subscribe, you'll be given notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos on YouTube and on rumble.com, all of which are free. If you do watch the videos, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance law, insurance claims, insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.